Good afternoon, participants and subscribers to day one of the Legal Aid Fair of the Norman Manley Law School Legal Aid Clinic. For those of you who are just joining us, we welcome you. And for those who have been with us since this morning's presentation, we're happy to have you again. My name is Christina Excel, attorney at law and tutor of the clinic. Of the Legal Aid Fair of the Norman Manley Law School Legal Aid Clinic. For those of you who are just joining us, we welcome you. And for those who have been with us since this morning's presentation, we're happy to have you again. My name is Christina Excel, attorney at law and tutor of the Legal Aid Fair of the Norman Manley Law School. I will be your moderator for this afternoon session. Today we'll be engaged on a topic that I am sure we are all interested in, and that has to do with what happens when you have an unpaid traffic ticket. Our guest speaker is eminently qualified to tell us about the changes to the road traffic laws and what happens when you have unpaid traffic tickets. And that is Dr. Garth Lyttle, attorney at law. Dr. Lyttle continues with us since this morning's presentation. Please share your questions in the chat at the end of the presentation. To introduce our guest speaker is Ms. Nedrika Mullings, our final year Norman Manley Law School student, and I now hand over to her.
Good afternoon, everyone. I feel privileged to introduce to you our guest speaker for this segment, Dr. Garth Lyttle, attorney at law. He is a veteran in this field, having over 40 years of experience in private practice. His legal career has been propelled by his academic background over the years. Dr. Garth Lyttle began his studies at the University of the West Indies, UWI, where he obtained his Bachelor of Laws degree in 1979. In 1981, he graduated from the Norman Manley Law School. He further pursued a postgraduate diploma at UWI in 1983. He received his executive master's in business administration at UWI in 2005 at the Mona School of Business. He completed his Master of Divinity in 2013 at the Canon University in the United States of America. In 2015, he received his Doctor of Religious Studies as well as his honorary doctorate in divinity at the Mount Olives Bible Institute and Seminary. He is the president of the Seventh-day Adventist Lawyers Advocates Association. He has been a constitutional law tutor at UWI Faculty of Law for 4 years. Dr. Lyttle has been a notary public since 2000 and currently serves as president of the Notaries Public Society of Jamaica since 2022. Please join me in welcoming Dr. Garth Lyttle.
This afternoon session, we'll be taking a closer look at the ticket situation. Firstly, these offenses you're quite familiar with, but I will just give you an idea as to how the law treats them. We dealt with this morning with the disqualification. If you drive while you're disqualified, then you will be sent to prison and prevent from holding or obtaining a driver's license for a period of time. But each offense that you hear I'm going to be dealing with, they are associated with a particular demerit point system. And we start by looking at if you drive without registration plate on your vehicle, or you have one registration plate and you're charged, you go before the court you're found guilty or you plead guilty, you're attached to a demerit point of 4. For speeding, the first category of speeding carries a demerit point of 2. The second category, demerit point of 4. And the third category, a demerit point of 6. Now, for dangerous or reckless driving, that each carry a demerit point of 14. And 14 means you're automatically suspended for 1 year. Careless driving carries a demerit point of only 4 points. So what you have here now, as counsels, 14 as against 6. If your client is charged with the offense of dangerous driving or reckless driving, I would suggest that you try your best to bargain with the clerk of the courts, offer careless driving, because if dangerous driving is accepted and you plead guilty to that, you'll be out of your license for 12 months. While for the same offense and you offer careless driving, it is accepted. So you will be charged the fine which is associated with it, and you have 4 demerit points, so you would have saved your license. So that is something for you to consider. Offenses like race speeding on a road, driving a motor vehicle under the influence of drinks or drugs, that is 14 demerit point. Now, driving the motor vehicle, you will be stopped on the road, and if the officer smells alcohol on your breath, or after every motor vehicle accident, you're generally tested for driving whilst under the influence of. Now, when you're tested, here is something as counsel that you ought to consider. There is one machine which is with the police on the road. It's a small machine, and they require that you should blow in that machine for your breath sample to be tested there on the spot. If you blow in it and it shows something to them, they're going to take you to another place where is it the machine, the breathalyzer 8000. Now that is the one that the test result will stand up in court one way or the other. If there's an attempt for you to test your breath on the road and you refuse to, then they must take you to the other place where the substantive machine is, and there you will be requested to blow in the tube which will lead your breath to the machine for processing. Now, if you fail to blow in that machine, then the number of points which we allotted to you will be 14, and you'll be suspended from holding or obtaining a driver's license. And that charge will be to refuse to allow yourself to be breath tested or for a specimen breath to be taken for analysis. So that is another 14 points. Failure to submit to breath analysis or willful alteration of the alcohol or the concentrate, which would be found in your breath, then that in itself again is another 14 point. Let me just pause here to tell you of a story about this alcohol stuff. The story is told of a man in England who was well known to the police as a man who likes his liquor. So one day he was driving from the pub towards his house, and the police tried to stop him. He did not stop. He drove straight to his house, went through his gate, entered his house, went to his drinks cabinet, took out a drink bottle, poured some, and then he went outside the gate to the police, holding the drink, holding the glass in his hand with his drinks. So they asked him, you know, a few questions. Eventually, they arrested him. So he went to court and told the judge that he was having a drink from his house. The judge would have none of that, and the judge convicted him for refusing to allow himself to be breath tested. You get the point? The point is this, is that police attempted to stop him, and he did not, because he was well known to them. And once you are tested and you're found to have tested on your blood, your alcohol level is at the point where the machine, the breathalyzer 8000, showing that it's at a level where you were drinking. And so you are now under the influence of drink. Then in such a case, it is 14 demerit points and you will be suspended for 1 year. The other point which is associated with this is blood concentrate. The alcohol might be in your blood, but for the blood concentrate, the police cannot test you. They would have to take you to a hospital where a medical doctor would be required to do the testing. And if when the blood is tested and they found that at the particular time you had alcohol in your blood, then on that basis, you will certainly be facing the court with the result from the doctor. No, there is absolutely no leeway in terms of the driving under the influence of, or if you have blood, alcohol in your blood. Now, there is another point which is added, which is a recent thing, and that is that it was touched on this morning. That is driving while smoking ganja. Or if you are in charge of a motor vehicle, you need not be found driving. Let us assume that you park the vehicle along the road or somewhere, and you're found smoking the weed. The fact is that because you're in charge of the vehicle, the police can still charge you for being in charge of a motor vehicle and smoking ganja. Another point, I'm just dealing with those in terms of 14 points, 14 demerit points. Not stopping after an accident. I repeat, not stopping after a motor vehicle accident. When an accident occurred, particularly an injury accident, you're required to stop, and the drivers of both vehicles exchange particulars, and the drivers ought to report the matter to the nearest police station. This is a very practical thing to do, because there are times when there's an accident, and because of the fact that people might gang you, you cannot stop. So the law says that you must report the accident to the nearest police station within 24 hours. Once you report the matter within 24 hours, then you're at least, you cannot be charged in that regard, and you cannot be associated with the 14 points that would be allotted to you if you did not report the accident any at all. Then the failure to report a motor vehicle accident. There are times when, well, the law distinctly says that if the accident is a minor one, and no personal injury occurred, then the parties again must stop and exchange information. At that stage, if the person wants to report it to the station, the fact is this: the law distinctly says if there's no injury accident, then the parties need only to exchange particulars. Other offense which might be of some import to you is that simple thing like tail light. The tail light over your license plate ought to carry a light, which is called the tail light. And if that light is absent, then you be charged, and that also carries a certain amount of points, and that is 4 points. Big 4 points for that, the absence of that light over the registration plate. And you can understand why. Because if your vehicle is on the road and somebody cannot see what the registration plate is saying, the letters and numbers on it, then it will pose a problem, particularly if there's an accident. All right, just a few more of the points, matters which will affect you as a person. Not causing a child to wear a seat belt while in the motor vehicle. This is a very, very popular offense. The child restraint system or the seat belt, you must activate it once the child is in the vehicle, and that is 4 points. Not wearing your protective helmet, this is for the motorcyclist now, 2 points. And failure to observe a silent zone, another 2 points. Look at this one. Overtaking in a manner causing obstructions to oncoming vehicle. You must have seen that, particularly the motorcyclists riding between or driving, I beg your pardon, between motor vehicles. I wonder if they're aware of the fact that this particular offense carries 6 points. Driving between motor vehicles or overtaking on a road in such a circumstance, that carries 6 points. Another popular offense is to be on a road and driving backward unnecessarily. Instead of going down and turning and come back or go to where you intend to go, you're reversed for some distance. The law calls it a case where you're driving backwards unnecessarily. I think you're allowed up to 2 car lengths only. 2 car lengths to reverse only. Beyond that, you'll be driving your vehicle, reversing your vehicle unnecessarily. So, all right, and then the final one, 2 more I want to deal with. Failure to obey red light or stop sign. And that is 6 points. You can understand the wisdom of red light or stop sign. There is really no distinction. One is light and the other one is standing on a pole. But those 2 carry 6 points each. And your failure to comply with school crossing, and that's another 6 points. These are the points, and this is the problem outside there. We hear the big problem with the point system. I'm going to just look at the system because I took time out to do what is called a process analysis of the point system as it is. And I have what is called a traffic ticket conundrum. Ready? Good. It's good to look clearly. Traffic ticket conundrum. At point 1, The police issues a traffic ticket. The ticket is recorded at the traffic headquarters, and that is at Ellison Road. And I can tell you, their system is accurate to the point where it records everything, everything. Cases that should have gone to court and did not, it records it. Cases that have been to court, but there is a shortcoming somewhere. Point number 2, the motorist pays on ticket within 21 days as the law stipulates. And that section of the law distinctly says that if you pay within 21 days, then the conviction will not be recorded anywhere. That's what it says. So here is it, the motorist paid within 21 days. But in truth and in fact, there's no record apart from the one which is at Ellison Road that shows that you were prosecuted on this day. So that ticket will still be outstanding. Though you pay, it is still outstanding. Point 3, if a fine is not paid, the motorist attends court within 31 days or at 31 days. And when you go there, let us assume that you plead guilty. If you plead guilty, then your money you pay and you go. But the record is still at Ellison Road that you were prosecuted. Point number 4. The motorist pleads not guilty at court and a trial is contemplated. And so you get a date. And it might take up to 12 months before the trial is completed. At that stage, it's either you're found guilty or not guilty. And no record is at Ellison Road on it. Point number 5, no statement on court file. There are times when the matter is ready, the defendant is ready, the prosecutor ready, but there was no statement on the ticket, accompanying the ticket for the matter to be tried. In such a case, a bench warrant was issued and the motorist failed to attend court, then the bench warrant will be sent out and the person will be arrested on the bench warrant, notwithstanding there is no statement on the file. Big problem for the administration. Now, we have had 2 amnesty granted, one in 2017 and one in 2019, I think it is. In 2017, persons went to the tax office, took advantage of the amnesty and paid. And again, there's no record of it at Ellison Road, cross-referencing the fact that money was paid by way of the amnesty. Another one in 2019, the same thing. No record is kept to cross-reference the fact that the police have them down as committing these offenses. And then the other record should be that the monies were paid by the persons. That is not there. And so we have a big problem. And I don't know who's going to try to resolve that one, but what is sure, and I can produce to you several bundles where persons have paid for the tickets and have the receipts, whether from the courts or the tax office, and they have copies of their copies of a ticket, and yet a printout, if it's obtained now from Ellison Road, where the data is collated in terms of the prosecution and recorded, you will see nothing of the fact that the tickets were paid, whether in court or the tax office. Now, this is posing a big problem, and a solution has to be found. Recently, the minister made an announcement that tickets before 1st of February 2018, all of those are whether forgiven or wiped out or otherwise. But the fact is this, he is expecting that the motorist who has outstanding tickets will pay at the traffic court. But that again is a big problem, a very big problem, because what about those persons who are holding their receipts, showing that they have paid, or those persons who cannot find their receipts, but they're relying on the fact that the government department ought to have accurate record of their paying at the tax office, and that is not there. The government has to find a solution. I know the solution, but I can't tell you. It's not my duty to find a solution, but the government has to find a solution to this particular problem. And on that basis, I wish to pause here and to ask you if there are any questions. Ms. Mullins, I'm ready to accept your questions.
Dr. Lyttle, we do have a question that I will now pose to you from our audience. It's a three-part question.
Sure.
And it says, what entity keeps track of the points taken off of licenses? Do we actively suspend licenses? And how many points would be taken off before a license is in danger of becoming suspended?
Right. I deal with the first one. The entity that keeps track of the number of points is the traffic area authority, or the traffic authority, which is separate from the police, which is separate from the courts. And those information will be fed to the traffic area authority, and they will keep the record as to how many points a motorist has accumulated over time. When it gets to the point where the person should be suspended, under the new act, it says that the traffic area authority ought to advise the person that he or she has accumulated enough points, and so the license is suspended, not shall be, but is suspended, and ask the person to turn over the license to the traffic area authority. I ask you now to understand this, that there's another stream in which a person's license can be suspended, and that is the court before which it appears. When you accumulate 10 points, your license will be suspended for 6 months. When you accumulate 14 points, your license will be suspended for 1 year. And when you accumulate 20 points, your license will be suspended for 2 years. Okay. May I have the last part of the question?
Yes, the final part of the question is, how many points will be taken off before a license is in danger of becoming suspended?
14.
Which is a 14 points.
14 points, yes. Okay. Any other question?
I'm not seeing any other questions at the moment, Dr. Lyttle. Thank you for answering.
Let me, since I have time, there is the question of driving. I think I dealt with it already. Driving under the influence. Yes, I think I dealt with it already. Okay. Now it's 3:00. If there's no other question, could you indicate to me?
I have another question.
Sure.
And that has to do with the analysis of the breath and the breathalyzer. Is there any basis to challenge the results or the methodology in your experience?
Yes, yes, you can. If you you're going to challenge the integrity of the machine. That is what the law says. When you go to the machine, and let us assume that the person blows in it, in the tube, and the machine processes, that's a breathalyzer 8000, it processes your breath, and the result come out, it ought to be printed on a piece of paper. The law is quite specific. That paper ought to be handed to you. You're to get a copy, I think within half an hour after it is printed out. If the time passes and you do not get that copy, that is one ground for challenging the integrity of the machine and the result that it might put out. Another area of concern would be to challenge the machine itself, but that it would be difficult. Actually, in the state of Colorado in the United States of America, one judge one morning, he dismissed about 3,000 driving under the influence charges. Why? Because they found one lawyer did his research and he found a fault with the system. And having found that fault, he was able to go to court and get the court to dismiss all of them. Since then, it was breathalyzer 2,500, but they have recalled those, modified them, and hence we end up with breathalyzer 8,000. That is what we have here, breathalyzer 8,000. But there is one other area of challenge. Matter of fact, what I did is that I did my research and I found out what the lawyer discovered. But I hold that one close to my breath because from time to time I get those cases. So I'm sorry, I have to hold this one close to my breath.
Very well, Dr. Lyttle. So research is very important.
Yes, indeed.
Would any member of our audience like to pose any other question? Please place your questions in the chat. In the meantime, I have another question, Dr. Lyttle.
Please
and
go
it has
ahead.
to do with the matter of the suspensions. If the license does become suspended, does one have to make an application thereafter for its restoration?
Yes. If the license is suspended by the court, the law says that you can, in section 24(3) of the Road Traffic Act, the existing act, and the corresponding one is in the new one, that within 6 months after you have been suspended, you can make an application to the judge or the court for the return of your driver's license. Now, this morning I read the areas that will be taken into account. The nature and extent of the offense which was committed. If you were driving under the influence of drinks or drugs, that is a consideration which a judge is going to look at. If you are charged with dangerous driving or reckless driving, those two offenses carry 14 points. Or if you've had a number of offenses, like sometimes I deal with matters and you find that a person will be convicted of, he pleads guilty to 12 offenses of speeding. Now, each offense under the first category carries 2 points. So if you have 12, that's 24. That's 2 years suspension. So the court will look at the nature and extent of what your offense is. It will look at the severity of them. It will look at all of those things and decide whether or not it will grant you your application to lift the disqualification. Yes. And on that basis, can understand a person who is dependent on his motor vehicle for a living, a taxi man, or whomever it is. The motor vehicle to drive himself is so important And all of those things the judge will take into account, but you have to base your application on the grounds of hardship. That is what the law actually says. It must be on the ground of hardship that you're suffering. Yes.
Grateful, Dr. Lyttle. One of our participants has a question, and it has to do with the matter of tickets that were prior to 2018, and whether you could repeat the discussion that you led in relation to that.
In an attempt to find a solution to the problem, the Minister of Justice, the Honorable Delord Chuck, he announced that tickets that were issued before the 1st of February 2018, if not paid, not dealt with, those would be, I'm not going to use the word forgiven, but those would be wiped out. So only tickets after the 2nd of February 2018, those are the ones before the court now. I hope that person understands. Using the benchmark of 1st of February 2018, those who were prosecuted before that, and the ticketing system started 2010. So those who were prosecuted before that, you can get your holiday there from the 1st of February going back for 2018. After that, those are the matters that ought to go before the court for consideration one way or the other.
Thank you for that clarity, Dr. Lyttle.
You're welcome.
I would again invite any other questions or answers as we are about to wrap up. If Dr. Lyttle would allow our audience members to type any lingering questions, any areas for clarification while we have Dr. Lyttle with us. I'll give just a moment, Dr. Lyttle.
Sure.
For that to be populated. Dr. Lyttle, one of our participants is seeking your views in relation to the following: that the government referred to outstanding tickets that can be paid by January 31st in order to have your record cleared, but going to the courts after payment, your license may still be revoked. What is the position in relation to that?
It's an excellent question, because that is a problem that a lot of my clients are now facing. The fact is this, is that you can clear the tickets, but once the judge imposes that suspension on you, once the number of penalty points accumulate, the judge is obliged to impose the penalty, which is suspension. Now, once the suspension is in place, you have to go to the law again, wait until 6 months pass before you can apply. And there's no certainty, because it is done at the discretion of the judge as to whether or not he or she wants to grant you the relief that you applied for. And on that basis, I think there ought to be some certainty by the minister. If you're going to say, take advantage of this, then you ought not to impose a penalty of suspension on the person. What is the use? If you think of a case where a man, quite recently, the fines imposed $600,000 plus 4 years suspension. I see no pleasure in his paying the money. Perhaps he might as well consider the alternative. But if you're going to go that route, you ought to have an incentive, because the greatest thing, the worst of things that can happen to a man is for his license to be suspended and his motor vehicle in the yard and he cannot drive it. I think another way ought to be found to deal with these matters. Hope I've answered that question.
I believe you did, Dr. Lyttle, and hopefully this discussion will propel us to some solutions sooner.
I'm sure, because I'm sure that there's a certain person who's watching now. Sure, the minister is watching. Yes.
So, Dr. Lyttle,
And this is the power of YouTube. You can pick it up anytime you wish.
that is so.
That is so, right. Are you finished now?
Yes, Dr. Lyttle. I don't believe we have any more questions at this time. I'm not seeing any more questions in relation to this segment, and I will therefore conclude the question and answer segment and now invite Ms. Lorna Gooden to give our vote of thanks.
Thank you. Good afternoon. Dr. Lyttle, on behalf of the Norman Manley Legal Aid Clinic and the students who are on and other audience, we want to thank you for taking the time out to spend the day with us, because I know you have been with us since this morning, and offering to us your 41 plus years of experience. Now, this topic on the tickets is very topical, and it is causing controversy, I see, among the taxi operators. And I'm thanking you for giving us, the lawyers in training, some insights as to how we can go forth to when we're dealing with our clients when we do get called to the bar. This topic is one that is dear to me. It is of interest to me. So you have even piqued my interest further, and I'm possibly might be seeking your tutelage and guidance when I am called to the bar or before.
Yes.
I want to thank you for offering your knowledge and your time. And I'm sure that the other members who are on are so guided and so minded. Thank you again, and enjoy the rest of your day. And I wish you all the best for 2023. Blessings and light, as I would say. Thank you.
Thank you very much. And to the management committee of the Legal Aid Department, I'm so happy. I'm thrilled to be here with you, and to be the first person to give a lecture in road traffic matters after the school was established in 1972, this being the first. I'm indeed happy. I'm thrilled to be that first person. And thanks for the day and for the lunch.
Yes, Dr. Lyttle, thank you so much for taking us through this topic today and during a very important time in the law school's history during our 50th anniversary, and for taking us through day one of the law school's legal aid fair. Thank you very much.
You're welcome. Thank you.
Ladies and gentlemen, this will conclude our live stream events for today, Monday, January 9th. Please join us tomorrow, January 10th, commencing at 10 a.m. for day 2 of our week of activities. If you would like to contact us about the services at the Law School's Legal Aid Clinic, you may send us an email at nmls.lac@uamona.edu.jm, or you may send us messages on our WhatsApp line at 876-561-9803. Please have a good rest of afternoon.